second subscription webinar entitled Hot Topics in Human Resources. We're obviously going to be talking about some of the latest and greatest news within human resources. We actually have a couple of recent updates that we've received in just the last week that we'll be sharing with you, later on in the presentation. But we do have a lot to cover today, so we'll definitely get started here. And please feel free. We do have time at the end for questions, so please keep track of any questions you have. It probably would work best if we hold those till the end so we can get through all of the information here today. And then we'll be sure to take questions at the end of the session. We're going to start out today talking about a very hot topic in human resources these days, and that would be social networking and social media. And I think everybody is starting to feel the effects, both positive and negative, of social networking within the workplace. Just to get started here, there's obviously a lot of benefits to social networking. First and foremost, it allows all of us to connect and communicate with colleagues and business associates, throughout the day. It's also a great way for us to connect with people that we haven't necessarily been in contact with for a number of years. So it's really great, a great tool to use for networking. It's also becoming a lot more widely used within the recruiting process. It allows us to communicate with applicants as well as customers and vendors. It also allows us to promote our organization's values, goals, products, services, and everything that goes along with that. A lot of organizations these days are using LinkedIn, Facebook, Twitter to talk about exciting things that are going on in the organization and to stay in touch with with prospects and customers and things like that. And along those lines, it also is a very great way to use, these sites are a great way to use for your marketing of your products and services, as well as for potential new hires in terms of getting information to them and allowing them to see more about what your company is about. And it's also a great way to help your employees increase their communication skills and become more technologically savvy. So there are definitely a lot of benefits to the social networking and social media in the workplace. Just as there are a lot of benefits, there is also the dark side of social networking. In the list, unfortunately, it seems to be longer on this side. So we have to be aware of all of the potential pitfalls as it relates to social networking. First of all, there is that fine line between, what's being productive and what's not being productive. And, as employees become more involved in social networking, both from a professional, standpoint, there's also that danger that they begin using these sites in the workplace for personal use, and that really gets into, productivity issues. I saw a recent article that mentioned the average employee wastes up to 2 hours a day on social networking sites. So it's very important to make sure that you are monitoring how your employees are using these websites and make sure that they're using them appropriately. I saw another article recently that was posted, and there was a comment. It allowed for comments after the article, and one individual who had read this article had posted a comment that their organization had recently done or did a check on a specific employee and had looked at their computer and their computer records and had found that this employee had been spending about 40% of her day on Facebook. So that's definitely a very scary statistic. So again, you want to make sure that you're monitoring that very closely and ensuring that employees are using social networking in the workplace appropriately. There is also an increased risk of lawsuits, and coming from a couple of different standpoints here. Obviously, with employees, there's an increased risk of lawsuit. We'll talk a little bit more about this in just a minute, but you're getting into issues with harassment and discrimination. We've also seen some lawsuits as it relates to individuals posting comments on Facebook and Twitter and things like that. So that's definitely an area that is becoming more frequent in terms of the lawsuits. And also customers as well, and this is something we probably don't think about a whole lot, but When you have employees who are out on Facebook or they're out doing blogs or doing various things on Twitter, you need to be very careful that your employees understand what they can and cannot be saying, and there is that potential out there. If employees are posting negative comments or negative remarks about competitors, there could be some issues there in terms of a lawsuit. So you need to be very careful about that as well. There's also the potential for the disclosure of confidential information and trade secrets, and this is why it's so critical for you to make sure that you are giving your employees very clear guidance as to what information they should and should not be posting on these sites. So if you are using Facebook and Twitter and LinkedIn and some of the other sites out there, you want to make sure that you sit down and figure out exactly what these sites are to be used for and what information is appropriate to be put out there. Obviously, there's the potential for damage to the organization's reputation, and some of this, is unfortunately going to be outside the control of what you're doing. If someone is posting negative remarks outside the workplace, if you have a disgruntled employee, but and we'll talk a little bit more about this in just a minute, but again, that is, a potential negative to using these sites. And we'll talk a little bit as well about union organizing, and social networking sites make it much easier for employees to get together and for union organizers to pull them in and begin to start talking about negative things about the organization. So again, just a few things here that make social networking a little bit risky in your business. In terms of the effects of social networking, obviously there is quite a bit of legal exposure for employers, and we're still starting to realize the effects of this. This is still continuing to play out in the workplace. But the legal exposure for employers, while employees are engaging in social networking, is not any less significant than harassment. So it is, really a serious issue that needs to be dealt with and monitored very closely within the workplace. And really what, as an employer, you need to be doing is figuring out how you would like your employees to be using social networking, and again, make sure you're setting those clear guidelines and communicating those guidelines. Social networking has also really blurred the lines between personal and professional lives. In the past, prior to having all of these sites, there really wasn't a lot of information out there just on the general websites or on the general internet about employees' personal lives. And now with Facebook being so prevalent and employers using that more and more as a recruiting tool, and even supervisors or other employees connecting with each other on these websites, there is a lot more personal information that is out there that and a lot of it is probably not information that you want your management staff or your employees to be knowing. So this is really becoming a very serious issue in the workplace and how that's used, and we'll talk a little bit more about that in just a minute as well. And as we've talked about, social networking does have some really positive effects when used properly. So employers really need to recognize, embrace, and manage the social networking activities within the workplace. There are several legal issues that you need to consider as you are looking at social networking and how it's going to be used in your organization. First of all, you need to be careful not to violate the National Labor Relations Act, and this has become apparent in the recent cases that have been brought before the National Labor Relations Board. The bottom line here is that employers cannot restrict protected activity, which means that you can't restrict an employee from lawfully discussing wages or terms or conditions of employment with their fellow coworkers. And this is where one of the recent cases came into play, because there was an employee who had been posting on Facebook, and she went home one night and posted some negative remarks about her supervisor on Facebook, and ultimately was terminated because of this. And she filed a claim with the National Labor Relations Board. Before the claim was actually decided, it was settled, and basically it was determined that the employer had very broad policies as it relates to social networking. Unfortunately, we didn't have this case go to court where we would have received more guidance, but we are going to continue to see cases out there that tackle these types of issues. You also cannot require an employee to seek advance approval for protected activities, which again would be talking about their conditions of employment or wages, things like that. And you must permit your employees to engage in protected activity in non-working areas during non-working time. What you can do is you can restrict communication related to work activities, and this includes confidential information about your work product. So obviously you have the right to expect employees are not going to be posting any information about trade secrets or confidential information about what's going on with your products or services, things like that. And you have the right to also limit or ban solicitation in the workplace during work time. So there are some things that you as an employer can do, but you need to be very careful not to restrict your employees' activity where protected activities are concerned. You also need to think about how you're going to deal with privacy issues, and this goes back to determining how you're going to properly monitor the use of social networking sites without infringing upon your employees' privacy rights. And one of the things you need to make sure here is that you do have a policy that contains a statement that the organization can monitor emails and business-related communication tools, and make sure that you're communicating that to employees so that they do not have any expectation that there is privacy within their computers or any other equipment that they're using. The other issue that's becoming a lot more of a concern for employers is how non-exempt employees are using these websites and social networking sites during off hours for business purposes. And from a much broader standpoint, a lot of your non-exempt employees these days are probably have smartphones or BlackBerries or other communication tools because the cost of these have come down quite a bit. So more and more organizations are giving non-exempt employees smartphones and BlackBerries. So you need to make sure, first of all, that you're monitoring what employees are doing in off hours and have clear policies about how they need to stop working if they're non-exempt when their workday ends, and that they shouldn't be picking up emails if that's the way that you want them to handle that. And that relates to social networking sites as well. If they are going online to post or do any sort of work in off hours, you need to make sure you're monitoring that as well. In terms of, and we talked a little bit about this already, but you need to make sure that your employees are not using any social networking sites to make negative remarks against your competitors or other companies in your industry or organizations in your industry. In order to gain a competitive advantage, you could be facing some legal action along those lines if that is happening. And probably one of the most important things that you need to be clued into right now is how social media can create issues of discrimination and or harassment. And organizations have the potential to violate Title VII if they're using social media in recruitment, for example, because there is a lot more information out there, as we talked about already, that is available to employers, and a lot of that information speaks back to someone being in a protected class, whether they're disabled based on age or based on things that they're doing outside of the workplace. So you need to be very, very careful about the types of information that you're picking up on Facebook and how that's being used in recruitment as well as in different areas of the business going forward. You need to make sure that that your managers understand that as well, and make sure that they're not going out into these websites and becoming privy to information that they probably would not otherwise know. You want to also make sure that all of your employment discrimination and harassment policies include a social media aspect and talk about how you expect social media to be used within the workplace. and that any actions that are discriminatory or that could lead to harassment are going to be dealt with and could lead to termination. As we've already talked about, it's very important for employers to take appropriate steps to make sure that employees know who may speak on the organization's behalf on these social networking sites, and also to determine appropriate content for the communication. So you need to keep a close watch on what's going out and even work very closely with those employees who are out there speaking on behalf of the organization. Some other things that you need to make sure that you're reiterating with your employees along these lines is, again, don't expect privacy. Employees need to know that the information that's posted on social media websites are not to be considered private, and remind them that whatever they're putting out there, good or bad, is going to remain out there for a very long time. It's going to be accessible, so you need to make sure that they are aware of that. Obviously, your employees need to be using good judgment. They need to you need to make sure that your employees understand that if the information that they're posting on a social media site violates company policy or affects their job performance or hurts the reputation of other employees or the company's business interests, they could be subject to discipline. Some employers take more of a hardline approach to this and really say that employees are prohibited from using social media during working hours. Again, this is going to go back to how your organization is using social media. If you're not using social media on a day-to-day basis on behalf of your organization, and you would prefer employees not, be online on any social networking sites, you can strictly limit this. You obviously need to be very careful when you're doing this because, again, if you have a policy out there that states that you should not be using social networking sites during working hours, you need to make sure you're monitoring that and you're managing back to that. And if you do, this obviously becomes a lot more tricky if you do have employees who are using social networking sites for business, because it becomes a little bit difficult to draw the line there. You also want to consider letting employees know that if they are out there posting on websites, for example, or social networking sites, LinkedIn, for example, that if they're making any statements or references that are attributed to the company, that the employees should notify readers that the views and opinions and ideas that are out there are their own views and that they're not endorsed or sanctioned by the company. An example of this, again, another area that's becoming a little bit sticky is on LinkedIn. If you're all familiar with LinkedIn, you know that you can, once you're linked in with individuals, you have the ability to write recommendations for employees based upon the work that they've done. And these are really sort of informal type references. And there's been some information, some articles, and some discussions out there about how this comes into play as it relates to organizations that have reference check policies, because most organizations out there do have fairly strict guidelines in terms of what employees or what employers will provide in terms of a reference check. And most organizations will limit references to name, rank, and serial number. So they're not going to give a lot of information. And if you have supervisors that are out there posting recommendations, that tends to, contradict that policy. So you need to make sure that, if employees are posting, you give them some guidance on this aspect as well. You also first and foremost need to remind employees about confidentiality. This is really important, and again, they need to know that they should not be putting any proprietary information out there, any trade secrets, anything that really shouldn't be disclosed to the public without discussing it first with an appropriate member of management. As it relates to social networking policies, we're going to talk for just a minute here on what what you need to include within a social networking policy. You may have some of this information already worked in within your computer use and your internet use policies as well, but you want to make sure that you're letting employees know that social media in the workplace is a privilege that comes with responsibility. And again, this goes back to having guidelines in place as to how an employee should be using these sites, if at all, during the working day. And that social media must not interfere with job performance. We've already talked about this next piece as well, really critical. Don't share trade secrets or confidential information within these networking sites. You want to also remind your employees that the organization owns the systems and the hardware that they're using when they're going out onto these sites, and that the organization will monitor the use of the systems and the hardware. You also want to remind employees that the organization expects loyalty, and you don't want them making negative comments about employees or products or services. Again, as we've already talked about, you can't have an employee that you can't prevent an employee from going out there and posting comments after work hours about their working conditions. So again, you want to make sure that you're not preventing them from talking about any conditions of work. We're now going to move into another topic here, the Illinois Religious Freedom Protection and Civil Union Act that went into effect on June 1st of 2011. So this is already in effect, and hopefully you've already had some conversation with your insurance carriers and brokers about how you need to comply with this act if you are a fully insured plan. Basically, this act indicates that any party to a civil union is entitled to the same benefits and protections as a spouse would be, and this could be for same-sex or opposite-sex civil unions. Domestic partners are not included in this. You need to actually have been entered into a civil union to take advantage of the rights that you have under this. And as I mentioned, it applies to fully insured plans. So you now have to offer the same benefits, health insurance benefits, dental benefits, and life insurance benefits as you would to a spouse if you're already offering those benefits to spouses and dependents on your plans. So again, you want to make sure that you're talking with your broker and insurance provider regarding the special enrollment period and communications that need to go out. You do need to have a special enrollment period after this June 1st date that would allow enrollment for anyone who in the past had entered into a civil union. And then going forward, it has to happen at your normal enrollment time, or there needs to be a special enrollment period following a qualifying event. So if a civil union is entered into, that would qualify as a special enrollment period. You also need to make sure that you're working with your payroll providers to make sure that you're determining the appropriate tax treatment for these benefits, because the coverage is taxable or imputed under federal tax law, but it's not taxable under Illinois state law because this is specifically an Illinois state law. So again, you want to make sure that you're working with your payroll provider to make sure that you're treating these appropriately. The other thing that employers may need to consider at this point are other policies, including leave of absence, adoption, bereavement, for example. There is no requirement under these areas to provide benefits under a civil union because there is no guidance in Illinois right now or under the federal law that says you have to provide this. However, some employers may choose to include civil unions as a criteria for someone taking a leave of absence, or in the cases of adoption or bereavement. So this is more from an employee relations standpoint in terms of how you want to craft your policies, but you want to make sure that you are specifically defining what a civil union is if you are going to be incorporating that into these policies. We're going to talk now about a couple of very recent things that have come down in the last week. The first here is something that came out last week from the National Labor Relations Board. And this is their attempt to make union elections quite a bit easier. I think we've all kind of heard in recent months and years that union membership is down. The unions are out there trying to do anything that they can to, beef up their union membership. And these announced proposed changes to the rules would basically allow for quickie elections. And there's a whole series of items that are being addressed within these proposed changes. There is a comment period right now that is open for 60 days, but it's being speculated that it's pretty likely that these changes will be passed and will go into effect. Some of the changes that they're looking to put into place would be permitting electronic filing and transmission of electronic positions. That's not the case right now. They're also going to be requiring a pre-election hearing that would be held 7 days after the hearing notice is served, and a post-election hearing 14 days after the ballot's counted. So what's going to happen is the unions are going to have a very short period of time here to get things moving, and then employers are going to have a very short time frame to respond. Right now, employers do have a longer time period where they can talk to employees about the unions and basically state their case, and that here is going to, if this goes through, make that very difficult. There was also another change that was another proposed change announced from the Department of Labor that kind of goes along with this. And basically this, if passed, it would substantially expand the reporting obligations and scrutiny of lawyers and outside consultants who advise employers in union representation situations, and basically would discourage many law firms from continuing to offer these types of services. So between the two of these acts, it's really going to change the way that the union elections are handled. So again, these proposed changes are open for public comment for 60 days, and they are expected to be adopted. So we will keep you posted on what happens there, as we have additional information. The bottom line right now is that as employers, you need to think about, developing ongoing education and communication programs for employees now that really focus on all of the benefits and the good aspects in terms of working at your organization. And this is something that you should be doing anyway, obviously to create good employee relations within your organization. But you really want to kind of take a look at, some of the other things. How likely of a target are you for unionization, and what might union organizers promise your employees that, or promise to them that you're not currently delivering? And obviously manufacturing organizations are a prime target for unions because there's a lot of, lower level workers who are, sat down and told, that they're going to get certain benefits or certain perks if they go into unions. So you really want to make sure that you are taking a look at, what you're currently offering your employees, and, think back to what some of your employees have, complained about. Are their complaints valid? And what can you do to handle those complaints and address them? And you might want to also think about the steps that you can take to make sure that, there's things, or putting things in place that will help keep you union free. And the other thing that you're going to want to make sure you focus on is training your managers and supervisors, again, about this and about why it's important to create a positive work environment. Again, this is really no different than what you would be doing otherwise. And again, we kind of were faced with the same topic within the last 2 years with the Employee Free Choice Act. If you remember that, this was another attempt to make it much easier for unions to come into the workplace. And the message here that we're sending is really no different than at that time, and that's just make sure that you are constantly taking a look at your employee relations and make sure that your managers are up to speed on what's going on, and what their role is in helping to prevent a union from coming in. Another recent development, which was actually somewhat of a positive thing for employers, is that there was a potential class action lawsuit pending in the court systems. It was a Wal-Mart, a case against Wal-Mart, and this would have been, I believe, the largest class action lawsuit. It was to potentially involve 1.5 million women who worked for Wal-Mart, which would have been a huge, huge case had Wal-Mart had to go through with this and had they lost. But the ruling basically made it more difficult for plaintiffs to bring nationwide class action claims into the courts. It's now expected that courts will require more evidence of commonality before certifying a class of plaintiffs. So as it relates to the Wal-Mart case, it really is going to focus more on what's going on in this case at the store level. Wal-Mart has company-wide anti-discrimination policies, but they have delegated those decisions to the store level. And the courts decided here that company-wide policies or practices didn't necessarily apply because they had the decisions at the store level. So the bottom line here for employees is that it did make it more difficult to bring class action claims, which is definitely a positive. In terms of what employers need to be doing, and this again is no different than had this case not been out there, and that is, obviously you need to make sure you're reviewing your employment policies and practices to make sure that you are in compliance with equal employment laws, and you want to make sure that your supervisors are trained in making employment-related decisions and that they are very aware of any applicable federal and state employment laws and having that clear understanding of how they're managing back to those laws. So having a strong anti-discrimination policy and harassment policy, which I'm sure you all have, and making sure that everybody is aware of this policy through training, again, with your supervisors. It's also a good idea to train your employees as well so that they understand the components of your policy. They know where they need to go if they have an issue and where violations need to be reported. And obviously, if you have issues of discrimination or harassment that are brought to your attention, you need to make sure you're responding quickly and meaningfully to any complaints, and you're doing a quick and thorough investigation of anything that has happened. This next item here, the Identity Protection Act, is only going to apply to our public sector employers or government employers who are on the call today. So if you are a private sector employer, you don't have to worry about complying with this particular act at this point in time. And this act went into effect on June 1st, and I'm sorry, that's actually it's 2010, but I believe that should be 2011. I will confirm that. Well, basically prohibits local government agencies from requiring individuals to transmit social security numbers over the internet unless the site is secure or the social security number is encrypted. And what this basically means is that employers need to have policies in place to address this and make sure that those who are coming into contact with have training on protecting the confidentiality of the information that is out there. So again, if you have specific questions on this particular act, we certainly can address them for our public sector employers and make sure that you have the policies in place and the training in place for your employers or employees. That is actually all of the information that we have today to share with you. I want to remind everybody right now that we do have a Twitter account and would encourage you to sign up for this if you are not already on our Twitter Twitter account, we do share with you all of the latest breaking news that we are informed of, anything related to employment law cases, things like that. So you want to make sure that you're signed up for that and following us so you can have all of the latest information. We will open it up right now. If anyone has any questions, there is a place where you can type your questions in, and we'll be happy to address that. If you have questions after, you can feel free to reach out to either myself or Joyce Grenis or Julie Strahl, whoever you are typically communicating with in terms of any subscription type questions that you have. And thank you for being here. We look forward to talking with you again in a couple months. I'm sure we'll have a lot more information and even more updates to share with you at that time.